I'm sorry.
It's 102.
Welcome everyone to the November 24th meeting of the Delaware Public Service Commission. I guess my microphone is on. The reading of the meeting minutes of November 3rd, 2015. Are there any changes, corrections, deletions, modifications, any interest in hearing anything more about the minutes of November the 3rd?
Move we adopt the minutes of the November 3rd meeting as presented.
Second.
Is there any discussion on the motion to approve the minutes of November 3rd? Hearing. Aye.
Aye.
Any opposed? Any abstaining? The motion.
Abstain.
One person has abstained, so it's a 4-0 vote. The motion is approved. Consent agenda has 2 items on it. Does any commissioner wish to take one of those 2 items off of the consent agenda? Is there a motion with respect to the approval of the consent agenda?
I so move.
I second.
Any discussion on the motion to approve the consent agenda? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. The regular agenda, the first matter is in the matter of the application of Chesapeake Utilities Corporation for approval of a change in its environmental rider. The commissioners welcome Mr. O'Brien from Chesapeake. Welcome, Bill.
Thank you, Mr. Chairman. Mr. Chairman and Commissioners, what you have before you is order number 8817. It's the opening order in docket number 15-1516, which has to do with Chesapeake's application to reestablish the environmental rider, which was initially established in, I believe, 1995. The rider was established to recover environmental remediation costs at gas sites. For several years, we were cleaning up the Dover gas site and the Smyrna gas site. Earlier this year, after several years of no environmental remediation costs, we began to incur costs related to the Seaford Town gas site. We have since entered into a voluntary cleanup program with DENREC, so we do anticipate incurring further costs into at least 2016. But the rate that has been proposed in this case is to recover the costs up to the end of the environmental cost year, which is September 30th, 2015. The order essentially speaks for itself, and Chesapeake certainly appreciates the help of Deputy Attorney General Mayrack and Deputy Attorney General Iori in formulating the order, and we urge the Commission to adopt the order and open the docket.
Thank you, Mr. O'Brien. Ms. Mayrack?
Mr. Chairman, Commissioners, as Mr. O'Brien has stated, you have before you order number 8817, which would open a docket to consider Chesapeake's environmental rider rate. It set temporary rates effective December 1st, 2015. It sets a schedule for publication of notice and comments, as well as petitions for leave to intervene. Appoints a hearing examiner for the purpose of considering those petitions for leave to intervene only, and then would schedule the evidentiary hearing before the Commission on February 23rd, 2016. I would like to propose just one minor change in paragraph 6, line 5. I would propose that we strike the words "wishing to oppose the application," which recognizes that there might be interveners that are in support of the application.
Any objection, Mr. O'Brien?
No objection.
Ms. Iori?
No objection.
The amendment is, I guess, going to be voted on as part of the end process.
Thank you. And staff would urge the Commission to adopt Order 8817.
Thank you, Ms. Mayrack. Ms. Iori?
Thank you, Chair Winslow and Commissioners. The public advocate had an opportunity to review the order and is satisfied with the form of order as amended by Ms. Mayrack.
Thank you, Ms. Iori. Is there anyone else here to be heard in this matter? Seeing none, any commissioners have any questions of the parties with respect to the environmental rider?
Chair, I move that the commission adopt order number 8817 as amended.
Second the motion.
Is there any discussion to approve, on the motion to approve proposed order 8817 as amended? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you, Mr. O'Brien, Ms. Mayrack, Ms. Iori. The next matter, the second matter is in the matter of the petition of Vivint Solar Incorporated for a declaratory order. And we're going to consider that petition and any other parties. Yes?
I believe number 1 is the application of
Oh, I'm sorry. I apologize. Everybody, no wonder if the wrong people were coming forward because they're the right people. My apologies. This is the second time in a row I've done that. This is the matter of the application of Delmarva Power and Light Company for annual update of its gas environmental surcharge. Welcome, Ms. Scott.
Thank you, Chair Winslow and Commissioners. Pam Scott here on behalf of Delmarva Power. This is our annual filing in connection with the gas environmental surcharge rider, which was filed on August 26th of 2015. Similar to what you heard from Bill O'Brien of Chesapeake, this is the rate that gets implemented to allow us to recover for the cleanup of environmental conditions at our sites, specifically at our site located at the Wilmington Riverfront. In this particular matter, the parties have reached a settlement agreement. The parties also agreed to stipulate to the testimony that has been filed in this particular application. I have one witness that I'd like to call for some very brief testimony, Kristen McAvoy. Ask that she be sworn.
MCEVOY.
Please raise your right hand. Do you swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth? Jen, could you state your name for the record?
Kristen McAvoy.
And by whom are you employed?
I am employed by the PHI Service Company, which is a subsidiary of Pepco Holdings and the parent company to Delmarva Power and Light.
And what is your position with Pepco Holdings?
I'm a Senior Regulatory Affairs Coordinator.
In that role, do you oversee the filing of the annual environmental surcharge rider application for Delmarva Power?
Yes, I was involved in the filing of the application of this docket, the preparation of testimony, and the preparation of supporting documents, and the review of the proposed settlement agreement.
And what is being proposed as part of the settlement of this docket?
The settlement is proposing to implement the rates as filed. This would result in an increase from a .00122 per CCF to a .00128 per CCF.
And to put that in layman's terms, what would be the impact to a typical residential customer?
For a typical residential customer in a winter month having 120 CCFs, for natural gas, it would be an impact of 1 cent on the customer's bill per month.
And in your opinion, is the settlement as proposed, would it provide for just and reasonable rates for Delmarva's customers?
Yes.
And is the settlement in the public interest?
Yes, it avoids the costs. It avoids any future cost expenses associated with further legal proceedings and saves customers from incurring those additional expenses.
And this is in fact the formal settlement agreement that was signed by the parties, is that correct?
That is correct.
I have the original document, if I may approach with it.
You may. Is there any objection to the admission of the document as petitioner's exhibit number 1?
No objection.
Ms. Mayrack?
No objection, but I believe we actually have 5 different exhibits that were attached to in preparation for the meeting, which included the application, the testimony, and as well as the settlement. Attached to the order. So I believe that the settlement is actually exhibit 5 as we have them before the meeting.
This is just the original with original signatures. Would you like me to give it to Ms. Nicholson?
Yes, please. So you want that to be exhibit number 5, exhibit number 1? Are there going to be any more exhibits? What's the number we're going to put on
Exhibit
there?
5 is the final exhibit.
Okay, then that's the final exhibit, so we'll make that exhibit number 5. We'll work the other numbers in, right?
Chair Winslow, attached to the form of order for this particular application is an exhibit log. All of these documents have already been filed with the commission.
Okay.
So Exhibit 1 is the affidavit of publication of the public notice. Exhibit 2 was the ESR application. Exhibit 3 was the direct testimony of Ryan Robichaux with Delmarva Power. Exhibit 4 was the testimony of Kristen McAvoy in connection with the application, and then Exhibit 5 is the settlement. And all the parties stipulate to those documents and the introductions into evidence.
Okay, so Ms. Iworry, that's correct as far as you're concerned as well?
Yes, Chair Winslow, thank you.
So all those exhibits are hereby, if not already officially entered, they're now officially entered. Thank you. Ms. Mayrack?
Yes, I guess, could I
Yes.
do cross-examination
Oh, I'm
of
sorry.
Delmarva's witness? Could you just briefly describe what the increase in costs, the amount, and as well as what they were for in this docket?
Sure. The increase of this year's costs were $953.46, and it had to do with expenses in for the long-term stewardship plan and some expenses for minor travel.
Okay, and this is all for the Wilmington South?
The Wilmington South site.
Okay, thank you. No more,
Wilmington Coal Gas South site.
thank you. No more questions.
You have any testimony?
I do. Staff would like to present Malika Davis to testify.
Swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do. Could you please state your name and business address for the record?
My name is Malika Davis, Malika. I work at 861 Silver Lake Boulevard, Cannon Building, Suite 100, Dover, Delaware.
And who is your employer?
Delaware Public Service Commission.
And what is your position with the commission?
I am a public utility analyst.
And as part of your duties as a public utility analyst, were you assigned to serve as the case manager in this docket 15-1333?
Yes, I was.
And have you served as the case manager for similar dockets in previous years?
Yes, I have served as case manager for the last 5 of Delmarva's 13 filings.
And as the case manager for this docket, did you review Delmarva's application for a change in its environmental surcharge rider rate?
I did.
And did you participate in reviewing and finalizing the proposed settlement agreement for this docket?
Yes.
And are you familiar with the terms of the proposed settlement agreement?
Yes, I am.
Could you please describe those for the commission?
Yes. The application proposed a slight increase, as Ms. McAvoy already stated, which would result in approximate 1 cent per month for increase for residential space heating customers using 120 CCF of natural gas in a winter month. And the rate is based on invoices totaling $953.46 for remediation costs for this environmental cost year. And the company estimates that it will collect a total of $266,706.10 during this environmental cost year, which runs from November 1st, 2015 through October 31st, 2016, which includes the amortized balance of $275,468 for the recovery years ending May 2011 through May 2015, plus a true-up of $8,762.20 for overcollection for the previous year's ESR and the 0.3% commission assessment. I did perform an audit of all the invoices and exchanged informal data requests with Delmarva. And based on the audit and the responses to the data request, the parties agreed to submit the proposed settlement agreement recommending approval of Delmarva's application.
And then just to reiterate, the impact on the average customer's monthly bill is an increase of how much?
Approximately 0.01 cents per month or 0.003%.
Okay, so 0.01 cents per month. Okay. And do you believe that the proposed settlement is in the public interest and that the and do you believe that it results in just and reasonable rates?
Yes.
Could you explain why that is your belief?
As stated before, I performed a detailed audit of the remediation expenses claimed by Delmarva for this year. And the review I did supported the amount of remediation costs claimed. I also reviewed Delmarva's calculations of the total amount to be collected during this collection period and concluded that Delmarva had correctly calculated its estimate. I reviewed the amortized balance and the true-up of the overcollection from the previous year. Also reviewed Delmarva's calculation of the proposed ESR rate and found that it was performed correctly. And because all the calculations were performed correctly and in accordance with prior commission directives, and because Delmarva has supported its application with invoices, I concluded that the proposed settlement agreement will result in just and reasonable rates. And additionally, I believe there's no reason to continue to litigate this matter, and the settlement is in the public interest because it avoids the need for staff and the public advocate to file direct testimony and Delmarva to file rebuttal, which will save the ratepayers money and reduce the additional regulatory expenses.
And is it your recommendation that the commission should approve the proposed settlement agreement between Delmarva, the public advocate, and staff?
Yes,
And do you have any further testimony to add?
I do not.
Okay, thank you.
Thank you, Ms. Mayrek, Ms. Davis. Ms. Iori?
No questions.
Okay, any commissioners have any questions of the parties? May we have a motion, please? Yeah. Question?
No, we have a witness.
Oh, you do?
Yeah.
Well, I think that Ms. Moucher should be heard myself.
Absolutely.
Welcome, Ms. Moucher. Thank you for being here to participate.
thank
I
you for having me.
apologize for,
The public advocate calls Andrea Melcher to the stand and asks that she be sworn.
Do you swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Melcher, would you please state your name and business address for the record?
Yes, it's Andrea B. Moucher. My address is 29 South State Street, Dover, Delaware, 19901.
And by whom are you employed?
The Delaware Division of the Public Advocate.
And what is your position with the DPA?
A public utilities analyst.
And what are your duties and responsibilities in that position?
Primarily, I act as case manager for all dockets opened by the Public Service Commission and in which the DPA has intervened. In that role, I'm responsible for review and analysis of utility filings and discovery, retention, and supervision of expert witnesses, and participation in the development of positions taken by the public advocate.
And as part of your duties and responsibilities, did you review the application of Delmarva Power and Light Company for a change in its ESR rates?
Yes.
And as the DPA's witness, you are aware that the parties have reached a settlement in this docket, correct?
Yes.
Do you believe that the proposed settlement results in just and reasonable rates for residential and small commercial customers and is in the public interest?
Yes, I do.
And why do you believe that?
The amount the company is requesting increases the ESR rate by approximately 1 cent per month on a typical residential space heating customer's winter gas bill. Delmarva provided the DPA with electronic copies of the invoices and backup information supporting its requested increase, and no issues were found. The calculation of the proposed rate was performed correctly. The case is straightforward, and there's nothing in the application that caused the DPA any concern. It would be a waste of time and resources to litigate the matter, and that would not be in the public interest.
Ms. Moucher is available for cross-examination by the parties or questions for the commission.
any questions of Ms. Moucher? She did such a thorough job, I'm sure there probably aren't any. And I don't see any questions of Ms. Moucher. Thank you very much, Ms. Iori, Ms. Moucher.
Thank you, Chair Winslow.
And as I was saying, are there any questions the commissioners may have on this matter? Seems pretty straightforward, and so I expect to hear a motion to approve it.
I so move to adopt 8818 as recommended by the staff. I second.
Is there any discussion on the motion to approve proposed order 8818? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you, Ms. McAvoy, Ms. Scott,
I'm sorry.
and all the other participants. Now, I see all the solar people on the edge of their chairs like I might be calling them next. So come on forward. The next matter is the matter of the petition of Vivint Solar Incorporated for a declaratory order. Welcome, gentlemen and lady. Scott, we need to have the petitioners introduce themselves and make sure that Gloria has their names correct.
Good afternoon, Mr. Chair and Commissioners. My name is Ian Liston, law firm Wilson Sonsini, representing Vivint Solar, Inc. in its petition for a declaratory order. With me today are my colleagues Todd Glass and Sheridan Pelker, who are admitted pro hac vice. Also with me today is Dan Black, who is the Associate General Counsel of Vivint Solar and will be our witness today. Can I call Mr. Black to the stand to be sworn, please?
Yes, sir.
Swear that the testimony you're about to give shall be the truth, the whole truth, nothing but the truth.
Yes.
Full name, sir.
Dan Black.
And with the Commission's permission, Mr. Glass will be presenting today.
Good morning, or good afternoon, Chairman, Winslow, and Commissioners. My name is Todd Glass, and I've had the pleasure of representing Vivint Solar since its formation 4 years ago today. Vivint Solar represents an industry of residential solar companies that desire to provide to residential customers solar service either through a power purchase agreement or a lease on somebody's home behind the meter, and to provide that using third-party financing. We filed the petition for declaratory relief or declaratory order to clarify the status of Vivint Solar and its subsidiaries that would enter the state of Delaware to provide these power purchase agreements or leases to residential customers. I won't go into the legal arguments at this point, but I would like to make a few preparatory remarks with regard to the procedural response to what the staff and the Deputy AG provided to the Commission last week. We believe that the Delaware Public Service Commission can and should issue a declaratory order in response to our request. Delaware PSE is enabled by statute to regulate public utilities and electric suppliers. Indeed, it is vested with the exclusive original supervision and regulation of all public utilities. Delaware Public Service Commission also has the ability to hear applications for forbearance for regulation, but something that we can't even do because we don't even know whether we're regulated as a public utility or as an electric supplier. Similarly, we recognize that pursuant to statute and legislation that the Delaware Public Service Commission is the body that issues orders implementing retail access and net energy metering in the state. So this jurisdiction is solely with you. Delaware Public Service Commission has authority to issue declaratory orders and indeed has several times. Due to Delaware Administrative Code 1001 Rules of Practice and Procedure allows for such petitions. We were told that this was the proper procedure to seek such clarification, and indeed, in 3 prior orders, the Delaware Public Service Commission has issued declaratory orders clarifying whether something is or is not regulated in this state. Order number 8632 in PSE docket 14-0297. Just last year, the Commission ruled on the matter of whether the Northeast Transmission Developer, LLC, which sought a declaratory order, would be regulated or not. Similarly, Order 5966 in PSC docket 01-454, there was a matter of an inquiry as to the Reserves Development Corporation considering its need for a certificate of public convenience of necessity, and that case indeed became one of the definitive cases of whether the Commission will exercise its authority. Similarly, in First State Power in Order 4286, the Commission did so. The staff and the Deputy AG have suggested that a third-party legal opinion is the proper procedure here. Actually, with all due respect, we think that opinion letters, they don't carry the same rule of law that we're seeking here and clarification that we're seeking. Indeed, such a letter would be highly caveated and conditioned, and it would not give us the clarity that we're seeking here. The fourth point that I would bring up is that Delaware is indeed special within energy project finance, not only in the United States, but throughout the world. We recommend to our clients that the corporations and the limited liability companies that they use in order to develop and finance energy projects use Delaware law. Similarly, we created in our office of Wilson Sonsini here in Delaware, we hired William Chandler, the former Chancellor of the Court of Chancery, to head our office here. Why did we do this? Because Delaware has clear law. Clear and predictable law is important to the development of any industry and any body of law, and we seek that here. We don't know why we would choose ambiguity over such clarity. Two final points, and then I'll be quiet. The implications of rejecting our opinion could be very significant. We are seeking this clarification so that we can access project financing, tax equity, and other type of lending. If there's a lack of clarity on this law by the Commission deciding not to answer this question at this time, such financing could dry up because the financiers do not want to risk the potential that banking institutions such as themselves would somehow, through indirect ownership of solar panels on people's roofs, be regulated as a public utility. And finally, we don't know why a company seeking permission and clarity as to whether they would or would not be regulated should be punished or kept out of the state when all we're trying to do is get clarity on where the bounds of the law is so that we can comply on the law. There are other people that have come into the state and are offering without such clarity, and we don't desire to enter the state with such lack of clarity, and so that is why we filed our petition for declaratory order. I would recommend to the Commission that Dan Black is here. He's been with the company since its very beginning, since he was, I believe, the first legal person in the company that's based in Salt Lake City, and has been key to the development of these customer-facing documents in relationship to the customers, as well as its regulatory compliance and its project financing. Thank you for your time. I'd be happy to discuss anything else further.
Thank you, Mr. Glass. Ms. Mayrack?
Mr. Chairman, I'm actually counsel to the Commission on this matter. If you have my memo in front of you, and I'm happy to answer any questions about the legal advice I've provided to the Commission, but I believe Ms. Donahue is representing the staff.
Okay, we'll hear from Ms. Donahue.
Staff wasn't going to present any testimony on this because I thought that was the agreement of parties, but we also agreed that we would have witnesses available if we did feel the need for testimony. So Ms. Knotts is here if we need any testimony, but you've been provided with a memorandum from Ms. Knotts. It's dated November 17th. It gives background information on staff's opinion on this petition. So if you have any questions, I can have Ms. Knotts sworn in. Otherwise, I think the statements made in the memo sum up staff's position in this matter.
Any commissioners have any questions of Ms. Knotts?
Mr. Chair, this gentleman who just made a presentation, I'm sorry, your name?
Glass.
Glass, Todd Glass.
My question, I think, and I'm not sure who can answer it, but how is what Vivint is doing different from the use of a gas-fueled generator behind the electric meter?
Well, it's a different mode of creating electric power, obviously. But what we worry about in looking at the laws as written and regulations is that the provision of electricity to a retail customer, such as a residential customer, could be deemed to be a public utility. I believe in a natural gas generator, as you say, behind the meter. That natural gas commodity is not actually that which is being regulated. It's rather the electric power that is, I mean, in our case, it would be the electric power. In that case, the fuel is being provided by somebody else.
Point of clarification. I guess I'm asking the question about, we have a storm, so someone takes a gasoline-fueled generator behind the meter and puts electricity in service on their property. How is that different than what Vivint is doing? That's the answer I'm looking for.
Thank you for the clarification. I'm sorry I missed the question. In the point where a residential homeowner buys a generator, puts gasoline in the generator to generate electric power during an outage, that is the customer himself or herself doing so. In our case, what's different is that Vivint Solar owns that generator or the solar panel on the system, that they own it rather than the homeowner owning it. Therefore, arguably, you could say that Vivint Solar owns electric plant that is creating electric power for sale to that customer through a power purchase agreement. That's different from homeowner installing a gasoline generator and producing its own power.
One follow-up question, please. So in that scenario, as you've described it, if I have a gasoline-generated electricity to provide in my property, presumption is that none of that electricity by excess is going back to the grid. Is any of the Vivint electricity going back to the grid?
Under the statute and the regulations allowing for net energy metering in the residential solar system, yes, power can flow back through the residential system onto the utility system through the net metering. So the power does flow out and then it flows back or is accounted for on a credited system through the net metering program.
Thank you. No further questions.
Well, Mr. Glass, you indicated that you felt that the law in Delaware was clear and predictable. That's one reason why a lot of your corporation, other corporations are here. But I guess that's not clear enough for you, right? That's why you need that clarification, correct?
Correct.
Now, Ms. Mayrack has told us that we do have the power to issue certain declaratory judgments, but not in this particular case. Are you privy to what she had to, how about expressing that opinion out loud?
Sure. In the legal memo I provided prior to the meeting, my advice to the commission is that although, as Mr. Glass said, certainly the commission has the power to issue declaratory orders under certain circumstances. It's my advice that this is not one of those circumstances, that the relief requested here really is more appropriately considered in a regulation docket. And the fact that at least one entity has sought to intervene in this particular docket and ask the commission to make a declaratory order that's in fact applicable to the entire industry suggests that there are at least these three other companies that are represented by this one organization that might be affected by a declaratory order issued here. And that's why the relief requested is really more appropriately considered in the context of a regulatory or a rulemaking regulation docket, that a more robust factual record would be able to be developed in the rulemaking process. And also, although no Delaware court has ruled on this directly, there is very persuasive case law coming from the Missouri Supreme Court where parties asked for a declaratory order equivalent in one case, and a Missouri Administrative Board issued that order, and the court later invalidated it, saying that that was really a general prescriptive advice, and it was invalid because it was made in the context of a case decision that's specific to one entity when it really applied to an entire class of similarly situated parties. So the advice I've given the commission is that it would be inappropriate in this circumstance to issue the declaratory order that's been requested.
And what was the language that you used in your memo that indicated what the scope of our ability to exercise a declaratory judgment? That describes the limitations we have.
Well, really, the Administrative Procedures Act, which governs this commission, contemplates that there's two types of procedures. There's rulemaking, which is prescriptive, which is applicable to a class of parties that are similarly situated. And then there are case decisions. Case decisions are for one party. So what we have here today is a case decision because one party is requesting that this commission make a determination. But really, when it is of a declaratory nature, it should be respecting the payment of money or resulting in injunctive relief, requiring a named party to act or refrain from acting, or threatening to act in some way required or forbidden by law or regulation under which the agency is operating. And those factors are not at play here.
I've been around the commission for now my 11th year. This is maybe I think it's the second time that we've been requested to make a declaratory judgment. I believe the last one was in a Delmarva case, if I'm not mistaken. That might have been a rape case. But in any case, it's very rarely that we have this argument made. And I think the limitations she's discussing are, you know, as you well know, we're a legislatively created organization. We only have the power that's there. There doesn't seem to be a clear empowerment given to us with respect to a declaratory judgment under these circumstances. And I invite you, Mr. Glass, to express your opinion on that.
First thing is I would look to order that was ordered 8632 in PSE docket 14-0297 in 2014, September 9th, entitled, "In the matter of the petition of Northeast Transmission Development, LLC for expedited declaratory order." In that order, you note that this company sought clarification, and you gave it. This commission did, just last year. I would be happy to hand over the other orders in which you have done so. I also invite the commission, I believe that the representative for the entity that sought to broaden this hearing is here today, and I believe that you should ask them, that entity, what its position is on this particular matter while they're here. I would say that Vivint Solar only seeks to clarify the law for itself, because we need this to be able to enter the state, to be able to finance residential solar projects in this state. We are not seeking a rulemaking, nor did we petition for a rulemaking. We sought only clarification of where we would stand within the law within this state. It was the other entity that tried to broaden this out and make it something that would be akin to a broad category of people or turn it into a rulemaking.
Ms. Mayrack, do you have anything else that you want to
Well, just looking at the order that 8632, I mean, this appears to be a factually distinguished situation where you have a transmission company that is seeking to move forward with a project with PJM, our regional grid company. So, it's in the context of the artificial island RFP. So that suggests that there's an urgency here, and a uniqueness to this situation that makes it appropriate for a case decision and a declaratory order within the context of a case decision as opposed to a rulemaking process. I think here, yes, you have one company asking for a declaratory order that is applicable, but there are other companies, as evidenced by the interveners, the potential interveners, that this would impact. And I don't see how the instant case is distinguished from the Missouri case law.
Mr. Glass, what you're saying is that, if I recall correctly, LS Power won a bid from PJM. In other words, they were the only dog in town, so to speak, and they had to come through Delaware. I think it's very clearly a different animal. I don't know why I'm into animals today, but it's a different scenario, isn't it?
No, absolutely. Absolutely a different factual scenario, but the question was whether you have the authority to issue a declaratory order or not. And I think you clearly have such authority. And the factual distinctions may be true, but it was somebody trying to get an order out of the commission clarifying that they would not be regulated as a public utility under the Delaware statutes. I would always also point to Delaware Code 1015, which gives the commission the authority to enter such orders and adopt regulations to implement retail competition. And the net metering programs that we were talking about fall squarely within that. The final thing that I would say is, to the extent that you have questions as to why we desire, why we need such clarification, Mr. Black is here. I think that he could speak on a factual basis on why this is.
I accept what your argument, which is that it's going to facilitate the financing of progress in our state for your company, which obviously we all would like to see happen. And we're not going to sit here, we're not attempting to punish you in any way, but we do have some questions about the limitations of our power. And we're very circumspect about that, and we're not going to do something that we don't believe we have the power to do, despite some adverse consequences to a party. Now, Ms. Knotts, with respect to this particular situation, let's assume that they decide to go ahead and seek financing, they get financing, they decide to start putting solar on top of rooftops. Does the commission have any thoughts about that?
Your Honor, or Chair Winslow, would you like to have her sworn in case she says something that we might want to have in the record for an appeal?
Yes,
Okay.
please.
Could we have Pam not sworn in, please?
You swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do. Can you answer that question, Ms. Knotts?
Yes. As I stated in my memo, we have several solar companies currently operating in Delaware that do financing and leasing agreements. In my research on this matter, and just from staff's perspective, is our regulation on this whole net metering was fully vetted, and I think it speaks to this. If you'd like, I can go through some of the background that may help in the net metering regulations and the statute changes. If that would help, if not.
Now, is Clean Energy one of those companies?
Clean Energy, I think they do some PPA leasing agreements. I'm not really sure. I know that there are several others. Solar City is in the state of Delaware. Longevity is in the state of Delaware. We don't, since we do not regulate them, we do not look at their PPA or leasing agreements.
I'm one of the customers, by the way. Mr. Glass, Ms. Scott?
Chairman Winslow, my name is Deborah Scott. I'm from the Department of Justice. I represent DENREC in this docket. I don't have any substantive arguments or testimony to offer. DENREC join staff's position in this matter.
Chairman Winslow, if I might,
Yes, sir, Mr. Glass.
can I ask a couple questions of staff's witness?
Absolutely.
And I'm sorry, I didn't get your last name.
Knots.
Ms. Knotts. Ms. Knotts, in the net metering program, I believe the rules and regulations provide that a residential customer may enter into either a power purchase agreement or a lease. Isn't this correct?
It actually states, and let me just look at these, lease and operate or contract with a third party that owns or operates. It doesn't actually mention PPA, but that's what the language is.
Thank you. Do the regulations that you just quoted in the body of regulations talk in any way about the third-party supplier that is on the other side of the contract or the contractual relationship?
I'm sorry, I'm not sure exactly what context you're talking about.
In the regulations you just quoted and pointed to, it talks about homeowners being able to engage in contracts or leases or what have you in order to avail themselves of solar and participate in the net metering program. Do the regulations state whether the person on the other end, those third-party solar providers on the other side of that contract, what regulatory status those entities have?
There is something in here that was added, Chapter 10, that says nothing in this section is intended in any way to limit eligibility for net metering. Services based upon direct ownership, joint ownership, third-party ownership, or finance agreement related to electric generation facility where net metering would otherwise be available. There's several different things that state, when it talks about community energy, net generating facilities, it specifically states in that context that this generating facility shall be subject to regulation as neither a public utility or electric supplier.
Yes, especially with regard to the community solar, but it doesn't say that with regard to third-party, non-community third-party solar providers.
I would beg to differ, I think, because community energy generating facilities could be behind the meter or standalone facilities. And again, it's just my opinion that the legislature wants to specifically mention that because it's already intended when they added to the statutory language about lease or operator or third-party ownership that it was already intended that that was allowed. That's my understanding.
So is it an accurate statement, to your knowledge, that the Commission, the Delaware Public Service Commission, does not regulate third-party owned solar companies as a public utility?
On the basis of that being a legal conclusion that you're asking from Ms. Knotts, and she's not an attorney.
Oh, let me restate the question. Ms. Knotts, does the Delaware Public Service Commission regulate Solar City and other types of third-party owned solar companies as public utilities?
We do not.
Does the Delaware Public Service Commission regulate Solar City and other residential solar companies as electric suppliers?
We do not.
Final question, do you have any information that the Delaware Public Service Commission intends to in the future?
To the best of my knowledge, I do not.
Anybody else have any more questions, Ms. Scott, or any of the commissioners?
Mr. Chairman, I just wanted to point out, we do have an intervener, the Energy Freedom Coalition of America, LLC, who I believe are here, who were granted intervener status by...
They were, okay. Oh, it's Mr. Batista.
The public advocate had also introduced in this procedure.
He's such a quiet fellow.
Thank you,
Mr.
Chair.
Batista,
Fellow Commissioners, it's correct. On behalf of the Energy Freedom Coalition, we filed a petition to intervene in this matter. As set forth in our petition, The Energy Freedom Coalition is made up of several members, of which are in the industry. One of them is Solar City. We are market competitors with Vivint. However, with respect to the issues presented in Vivint's petition, we were aligned. The reason we broadened the scope in our petition was to guard against any adverse rulings that could come. We sought intervention on that basis to protect our interests and the interests of other members in this energy field. Based on what was said today, I see three courses the Commission can take. First, the Commission can defer to Ms. Mayrack's opinion and leave this to a regulatory rulemaking or legislative initiative. Second, the Commission can opt to entertain the request by Vivint. If that is the case, then I would request that the matter be fully briefed and given the parties ample time to present their arguments. Or third, and to the extent that the Commission could do so, is craft an order which is specifically and narrowly tailored to Vivint, which would not have any negative implications with respect to Solar City or any of the other members of the Energy Freedom Coalition. So hopefully that will give some background to the Commission with respect to our position and the reasons for intervention.
Thank you, Mr. Batista. Ms. Iori?
Thank you, Chair Winslow and Commissioners. The Public Advocate did not submit any comments on this, but as I've been listening to the discussion between council or among council, I distinctly remember the Northeast Transmission Development case. In that docket, LS Power came in and wanted to be sure that it wasn't going to be regulated as a public utility. And I recall that Commission's counsel at the time argued that the Commission did not have the ability to issue a declaratory order that LS Power wanted for many of the same reasons that Ms. Mayrack has given, but the Commission found otherwise. So I would suggest to you that you do have the ability to consider Vivint's petition. If you do that, then the question is, well, are they a public utility? If you find that they are, then you have, the statute also gives you, or the law also gives you the ability to refrain from regulating them. But I think that, the first question that you have to answer is, do we have the authority to issue this? And I think we do, or you do, because the issue in this case is the same as LS Power. It was a different company, and it was in a different part of the energy business, but the issue is the same. Is this company a public utility? The Commission found in the case of Northeast Transportation Development that it did have the authority to issue a declaratory judgment and did so.
So you don't think the distinctions between LS Power's position, which was that they were the only entity that could build the line, makes any difference at all?
No, I think that's a distinction without a difference, because the final question is the same. Is what this company is doing, does that subject it to being regulated under the Public Utility Act?
Okay, thank you. Ms. Mayrack or Mr. Glass, Ms. Scott, any questions or any arguments with respect to that?
I would just say that I agree, and I appreciate the clarification of the history there. As to Council's other point, our ultimate goal here is to be able to come into the state. We're the largest provider in Maryland, and Vivint Solar would love to come over the line and start providing services here. They would like the clarity to be able to do so. We need not have it in the form of an order, declaratory order. It could be just an order, stating as much that you are not regulating such companies in the order dispatching our petition. At this point, we don't care the form. All we need is the clarity that we get into the state and that neither we nor our financiers or others, by doing so, will be regulated.
Chair, I have a question.
Yes, Commissioner Gray.
Mr. Glass. If Energy Freedom Coalition members can function without declaratory orders, then why does Vivint Solar need one?
I think that's a very good question for them to see how they got comfortable with it. We have looked at the law. We've talked to all types of counsel, and we have not been able to see a clear sight through the ambiguity as to whether or not we hope that, as Commission staff says, that there is no regulation, that you will not regulate. We need clarity in order for the company to operate. We don't enter any state unless we take a conservative approach to compliance with the law. We are going to be squarely within the law in any state in which we operate, and our financiers recognize that in us. So Vivint Solar has not been able to see this clear line of sight to whether or not it'll be regulated. I think the better question is how did they get comfortable?
Does the gentleman have a comment in response to that?
Yes, Commissioner. With respect to some of the members of the coalition, they did seek the course of obtaining legal advice on that matter. With respect to all of them, I can't speak with certainty as to that. And with respect to the entity itself, they are pursuing that course of action. As with any legal opinion, you come down to making a business decision. You weigh your risks and benefits, the status of the law, the history of the law. We've had the staff testify today that as of today, they're not regulating. To the extent that the Commission decides in the future to regulate, well, there's a process for doing that. We understand the process. I've advised them in that process, and we can have input into that process. And based on that, the company makes their business decisions.
Ms. Donahue?
Yes, just as a clarification, I believe, on staff's position, based on the additional arguments that were put forth by the companies and the DPA, staff would like to point out that one of the issues we had with this particular petition was the lack of facts and the clarity with regard to the contracts that the company is using for the PPAs and the solar leases. We're not certain, because we don't have any contracts filed with this petition, whether or not there is a possibility that any portion of, say, the PPAs might have a sale of electricity. In the petition, there's sort of a summary argument regarding the solar leases. And again, we don't have, before the Commission right now, any of the terms of the contracts which state anything other than the fact that the customers are required to purchase all of the electricity that's generated by the solar panels. So although the petition does have some facts in it, it doesn't have enough facts, staff believes, that would allow this Commission to clearly rule on what this company is seeking. We would also argue that any kind of order that you may want to fashion has to clarify why a rulemaking proceeding would not be able to clarify the same issues that have been raised by this company. Staff does believe that the net metering regulations are clear, but to the extent that this company has raised any issues that you believe are not currently covered by the existing regulations, why is it that this Commission could not reopen the net metering regulations and clarify what the company is seeking? Because you clearly have other parties interested in the same issue that this company is pointing out. They may already be operating in Delaware, but that doesn't mean that there's no business risk in what they're doing, or that maybe the Commission will decide tomorrow, hey, there's some loophole here, or that these companies should be regulated because they are selling electricity, whether it's in the form of solar power or something else, and whether they're connected to the distribution lines or not. So we have a lot of facts that are unclear. We don't have any arguments so far about why this cannot be clarified by a rulemaking proceeding, by reopening the docket, and also providing some clarity to companies that are already offering services, solar PPAs or solar leases in the state of Delaware. As Mr. Batista has pointed out, the companies that are currently operating in Delaware have been given legal advice. They have gotten the third-party opinion letters. It was something that staff has pointed out is available to this particular company. If that is not enough of a business assurance or financial assurance to the company, then perhaps they should petition this Commission to reopen the net metering regulations and put forth the specific language that they believe would protect them Those would be our arguments, Your Honor.
Thank you very much. The language in the Administrative Procedures Act contemplates that a case or case decision is an administrative adjudication that does include, without limitation, those of a declaratory nature respecting the payment of money, which I respectfully submit the LSI Power contract was about, the payment of money to put in a line. That might be stretching a little bit, but that, I think, arguably, there's where we went. Or resulting in injunctive relief. So I'd love to be able to, in my own mind, stretch this thing out and say, sure, we can give you a declaratory judgment. I think that this opens up the whole thing to the whole industry and issues. And of course, I guess we could do number 2 that Mr. Batista wanted to do. We could do number 3. But Mr. Glass, I think basically you've heard the testimony. You've heard what Ms. Knotts had to say, right?
Yes.
I'm a customer of one of those companies. I'm not going to be ruling in your favor for declarative relief. I don't think it's applicable under the law. So that's my position. Any other commissioner have any comments with respect to the situation?
Please.
This is a question for Mr. Glass or Mr. Black. I'm not sure. With the company, you operate in 10 states, and in those 10 states, are you regulated as a public utility in any of those?
Correct. And since our filing, we've opened up additional states. We currently operate in 13 states, and in none of those locations are we regulated as a public utility.
Was that clarified by declaratory order?
No.
Thank you.
Commissioner Gray?
If I could just to be clear on that last response. In a number of states in which they're operating, it is clear in the regulation that third-party owners of solar projects are not regulated as either utilities or electric suppliers in those states. We are currently pending before the New Hampshire Commission a petition for declaratory order, very similar to the one that you received. So just wanted to make sure that we were clear on that.
Thank you.
Yes, Mr. Chair. I have a few concerns. I've listened to all of the testimony, and my concern is that there's issues here of scope. So it's not just Vivint, it's the relative consequential impacts on other operators within a state. And to be honest, I'd often like to make informed decisions, and I really don't sense that there's a lot of information in front of us, in front of me, in order to make an informed decision about something that could cascade through your industry in the state of Delaware. And I have the public interest in mind as I'm walking through many of these things. So in some of your data, in some of the evidence we were given prior to the hearing, it seems that you're offering fixed leases for energy. So, if I have less sun in a given period of time, I'm going to pay a fairly high price for my energy. If I have more sun, I'm going to pay less. So the price to the customer is going to fluctuate up and down, and I don't know what the consequential impacts for that are going to be. Another concern has been about this commission's authority, and this is, I think, a question either for the legal counsel, but if we step back and consider rulemaking, for example, as perhaps our legal advisor has proposed, would we then have the authority to build a record, make informed decisions, and assert authority in this matter? Or are we going to be in a different place if we went down that road than we are today? Now, I've taken Ms. Iori's comments in mind, so I can assume we have the authority today, and we'd have authority if we were rulemaking, but it's not clear for me.
I can address the second part of that. Yes, I think you do have the authority. The next question, though, is whether they're a public utility. And I'm not sure there's sufficient information in the record that we have so far for the commission to make that decision. If the commission were to find that it does have the authority to issue a declaratory ruling on Vivint's petition, I would suggest, as Mr. Batista did, that the parties brief the issue of whether these providers are a public utility or not. But I think we would probably need to do a little discovery on that, simply because, as staff pointed out, there seem to be some facts lacking. I mean, part of the reason that the public advocate did not take a position in this was that we just didn't feel comfortable making a recommendation to the commission on whether these parties are public utilities or not.
And
Because of the lack of information.
I don't sense that the information is in front of me either, so
Commissioner Gray?
I'm reluctant as well.
To follow up, Commissioner Gray, we agree that you have the rulemaking authority to go forth, create a record, and create rules that would so clarify. Absolutely. In this docket, among council conversations prior to this, it was a decision that we would come forward on as a legal matter and a legal decision for the commission. We would, of course, invite the commission to do further inquiry. We will gladly explain the solar power purchase agreement and the solar lease, and explain that the lease is actually a lease of equipment, which does not actually fluctuate. The payment doesn't fluctuate depending upon how much sunshine in that particular month, versus the power purchase agreement, which is a sale of the actual energy. We would be more than happy to do that. We did not think that the commission was ready for discovery. We would, of course, be happy to go forward on discovery to the extent that that's what's required. The last thing I'll say, that a rulemaking process is likely to be a 6 to 9 month type of endeavor. Maybe it could go more quickly. That would be great. At this point, there's a 30% federal investment tax credit that makes the cost of solar for customers and the companies involved far cheaper. That expires at the end of December 31st, 2016. We would like to enter the state and provide, services prior to that 30% going down to 10% on January 1st, 2017. That's honestly one of the considerations we considered in seeking declaratory order, because it's quicker, or it should be quicker. As we said before, what we're really looking for is clarity so that we can provide our services. But of course, if you want further process, if you want to develop a record, we'd be happy to do so.
One last question, Mr. Chair. So are you saying that without this declaratory order, you cannot enter the state because others in your industry apparently have?
I'll let Mr. Black enter.
Yeah, and as Mr. Glass has pointed out, and sorry, I forget your last name. Batista. It does come down to a business decision on the risk that a company is willing to bear when entering a state. I'm internal legal counsel for Vivint Solar, and I have been for the last 3 years. And when we've looked at entering into new markets and new states, as Mr. Glass has pointed out, we've chosen to be conservative in our interpretation of the law so that when we're selling to consumers and when we're financing this with large financial institutions, that we are making representations that we can live to, that we're not breaking the law fundamentally. And so when we look at Delaware and there's an ambiguity as to whether a third-party solar provider would be regulated as a public utility, being advised by local counsel and Wilson Sonsini, and myself included as internal counsel, we've taken to date the position that we could be subjecting the company and ultimately our customers to a negative effect if we were regulated as a public utility. And because we're entering into long-term relationships with these consumers, what we're talking 20 years, and that's the same across the industry, we wouldn't want to be signing customers up today with some of the language that I've heard from both staff and from the commissioners that, we're not looking to regulate this industry, so just get comfortable with it. If that were to change in the course of 20 years, and we know that the law certainly does change, but if the commission were to take a different view, or staff were to take a different view, that would have detrimental effect to existing customers that are under contract, not to mention expansion and new customers. So that's been our position of why we have not entered the state of Delaware, why we have not entered New Hampshire, because there is a lack of clarity.
Hey, Commissioner, I have a motion with respect to the request for a declaratory judgment.
I move that we accept the staff recommendation of dismissing the petition for declaratory order.
Is there a second to the motion to deny the petition for declaratory relief.
Second the motion.
Is there any discussion on the motion to deny declaratory relief? All those in favor signify by saying aye.
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 All those opposed? All those abstentions? The motion passes unanimously. Mr. Black, Gloria does a great job writing up the record. We got Ms. Knott's testimony, you might want to keep it. Okay, next, thank you, gentlemen, very much. Appreciate your attendance. Is there anyone from the public that wishes to make comment to the Public Service Commission? Does Mr. Williams have any comment he'd like to make to the Public Service Commission?
Thank you, Mr. Chairman. Just want to say thank you for offering the use of this room last night for our public hearing, and to remind everybody in the room that our RPS cost cap regulation is open for public comment and will remain open for public comment until 4:30 p.m. on December 8th.
Mr. Noyes, while you're still here, this is not on the agenda, but I received an email from an attorney in Massachusetts, and he wishes the state of Delaware, through the Public Service Commission, to issue a declaration that this commission, number one, works closely with DENRAC, number two, is supportive of the Clean Power Plan, and there's a couple other minor sort of situations. And I advised that person that I was not in a position to speak on behalf of the commission. We could not act on that, but that we would try to put it on our calendar for December the 3rd so the commission can discuss that issue and make a decision as to whether or not we're going to be supportive of the people in other states that are being supportive of the Clean Power Plan. And Mr. Cherry is copied on one of the emails I sent, so he knows about that. And I want to make sure that you were aware of it, and everybody else was aware of it.
We will be watching the agenda, and we appreciate your interest.
It's part of our job here. I mean, the Clean Power Plan is a huge step being made toward a cleaner environment, opposed by a lot more states than it's apparently approved by. So it's going to be interesting to see what happens as time goes by. Bob and I can get back in our retirement, and we can chuckle about it when the decision finally comes out. I think so. Mr. Howitt.
Chairman Winslow, Commissioners, I certainly want to thank you for our wonderful lunch today. I'm sorry that members of the audience weren't able to participate, but the Commissioners did curry favor with staff today and buy their lunch for them, so I just wanted to thank you for that.
You're welcome. I haven't chipped in yet, though.
I would like to make note that our next commission meeting is now going to be on Thursday, December the 3rd. We're moving off of Tuesday, and we're moving to Thursday, December 3rd, by virtue of the scheduling issues that we've had to consider. Lastly, at that meeting, we will have evidentiary hearings on basic service tier rates, equipment and installation charges for Comcast, and specifically Comcast of Delmarva, the unincorporated areas of Kent County, and the unincorporated areas of Sussex County. We will have hearing with Comcast of Eastern Shore, LLC, on the unincorporated areas of Sussex County, and we will have evidentiary hearing on Comcast Cable Communications, LLC, on unincorporated areas of Newcastle County. Just to make you aware of some of the excitement that will be happening at our December 3rd meeting. I would also like to take this opportunity to wish staff, the commissioners, the public advocate, and everybody a happy Turkey Day.
And to you.
Thank you, Chairman Winslow.
Thank you, Mr. Howard. That's it. Thank you all very much. We'll see you on December 3rd.
Well,
I'm sorry, say again?
agenda item on there?
Right, everyone, yeah. Yeah.
Something about the clean power and the declaration?
11:30 on the 3rd, right, Mike?
Yeah.
Really? Okay. Okay, do I give the